Hi, everyone, and welcome to this month's Title Now. I'm Melissa Murphy, General Counsel here at the Fund, and I get to host these monthly sessions that we have where we try to talk about and have good conversations about current issues in the real estate and settlement services industry or the real estate licensee industry. Whatever we think might be of interest to fund members and others who have signed up, so we welcome you. And a reminder that we push the audio portion of this out on our podcast, which is also conveniently called Title Now. And it's very easy to subscribe. It's free, just like this webinar is free. And all you have to do is to go wherever you get your other podcasts, search for Title Now, and please become a subscriber. I would love to have you on our list of subscribers. But the podcast is the way that you can listen to the content again or very easily share it with friends and colleagues that you think would be interested in hearing what we're talking about today. So I encourage you to do that. So what are we talking about today? Well, it seems to me, in all of my years of practicing law and handling real estate transactions, I learned to appreciate the relationship that attorneys have with Florida Realtors. And I have learned now through my position here at the Fund and my experience here at the Fund that relationship is not just the day-to-day stuff where I'm working with a real estate agent that may have referred me business, but there's actually a lot of synchronicity and compatibility between attorneys as an organization and Florida Realtors as an organization. And that is certainly true of the Fund. We've had a great relationship with Florida Realtors for many decades. And so over the past several years, there have been so many opportunities for us to talk about issues that cross over to both industries. They may present, the challenge that those issues present may be a little bit different for the realtors to deal with and the closing agent to deal with, but nevertheless, there are so many new ways that both industries need to learn to work together. And one of the questions that I love talking about, or that I love to pose to people from Florida Realtors is, what questions do Florida Realtors have? What challenges? What are their pain points? And because through learning about their pain points and the kinds of things that they're confused about, it really helps our industry be more helpful and more supportive. Because don't we all just want our clients to have a super successful transaction at the end of the day? So with me today are Shannon Widman, Deputy General Counsel here at the Fund, and Rich Swank, who is Associate General Counsel from Florida Realtors. And we are going to talk about how realtors get answers to their questions. And I liken this to the resources that we offer to fund members. We have the regulatory compliance email that you can send to us. How many of you have picked up the phone and called Shannon with a question about the NAR settlement, or called me or Michael Rothman about questions you may have about regulatory compliance or the new foreign interest in real estate law? Phone a friend is basically how we ought to market that, Shannon. We ought to have a whole new marketing campaign about phone a friend, because Florida Realtors has something very comparable, and they've had it for a long, long time. And I think it's called the hotline, Rich.
Yeah, legal hotline. Yep.
Yeah, legal hotline. So why do you have a hotline?
Well, because our realtors, for the most part, are not attorneys. And they deal with a lot of legal concepts, whether it's contracts, landlord-tenant law, closing questions, financing questions, things along those lines. And they, again, aren't attorneys. So we, as a resource to them, give them education and guidance with all of these things that they face every day. And that's really the value of the legal hotline. That's why we do it.
How long has it been around?
Oh, geez. Well, longer than I have, I think.
That long?
Yeah. I think at least 20 years, something along those lines. Yeah.
So, Rich, it's my understanding that some of the local MLS associations have their own hotline.
Right.
Give us a circumstance in which a realtor might reach out to a local hotline versus the Florida Realtor hotline, and why would they call Florida Realtors over local?
Okay, so without getting too technical, the National Association of Realtors, they publish rules for MLSs. Okay, some of them are mandatory and some of them are voluntary. Because the different MLSs are all the way across the state, across the country or whatever, different MLSs have different approaches to different things. And so they have their own rules on a local basis, okay? And if we are called with a question that is something that's, like basically a mandatory rule, an MLS NAR rule, we can comment on that. But if it's some local thing, then we really can't, right? Because we don't regulate the local MLSs, we don't supervise them in any way. And we don't want to, give the wrong advice with respect to a particular local MLS question. So that, if we are called with a question about that, we will always refer it to the local MLS so they can answer that question.
That makes sense. So how does the hotline work?
Okay, so basically, a member can pick up the phone. They do have to be a member of Florida Realtors. But it is a free service. We charge nothing for it. And you can use it as many times as you want. And some of our members use it quite often, sometimes multiple times a day. But anyway, they just pick up the phone. They dial the number, 407-438-1409. Then they give their licensing information on the phone, and then they will be sent through to they may be in a queue for a little while, depending on how busy it is. At any given time, I think we have between 10 and 12 attorneys that handle the hotline. And so then they will be sent through to the next attorney who picks them up. It's totally random. We do not have I want to talk to this person type of thing. It goes straight through to whoever just happens to pick up the phone, and then they answer the question to the best of their ability.
What if that agent is phone averse and doesn't want to wait on hold? Is there an email option? Is there a web option? How does that work?
Yeah, you can go to our website, floridarealtors.org, go into the member services section, and you will have to log in just as you would if you were on the hotline with your membership information. And then there is a box that you can check and use a email. You can send an email. Now, we do not respond via email. We always respond with a telephone call. So that's something they need to keep in mind. We don't give written opinions, for want of a better word. So, if you have sent an email, and you see our number pop up, make sure you answer the phone.
That brings up a good point, because I don't know how many of you as members have ever had someone say, "Oh, I just have one quick question," and they want to email that to you, and then your answer turns into a follow-up question, and then maybe another follow-up question. So it does make sense that you email the question, you receive a phone call back, and then you can have that conversation with the attorney on the other line. That makes good sense.
Well, and it's like I say during some of our trainings with our members, attorneys are trained to issue spot, right? They know that they can kind of boil down whatever the story might be into, concrete legal issues that they can then address. Most real estate agents are not trained that way. So the story they will tell you on the phone or in the email or whatever may have a lot of superfluous issues in it, a lot of superfluous facts, or they don't recognize the key fact as something that they kind of left out. So you get when you get used to it after you've talked to them for a while, that you start to tease out exactly what the important issue is, and then you can address that. And a lot of times that won't come through in just an email or even the first phone call.
What types of questions do you get on a regular basis, and what are the hot topics for the hotline right now? So
any question having to do with the contract is always evergreen. The one that we hear most often is counting time. It does not really seem to matter how explicit the contract is with respect to how time is counted. And it's kind of amazing to see what people can read into, never doesn't say business days anywhere in that section of the contract, but somehow that always seems to creep in. But counting time is a big one. Financing is a big one.
I was going to say the financing contingency has got to be a paragraph that gets a lot of questions.
Yeah, financing contingency, inspections is always a big one. How much access do I have to give the buyer or the buyer's agent? Things like closing fees, money down, stuff like that. So that, I would say that's probably, I don't want to call it the lion's share, but a lot of our questions are related to the contract. In some parts of the state, there is a very vibrant rental community that uses real estate agents in order to place tenants. We take a lot of calls on landlord-tenant stuff, primarily from those sections of the state, Southeast Florida, for the most part. And then, like you say, we have issues that bubble up, that pop up. Condos is a very hot topic right now. The foreign ownership law is a very hot topic. And of course, implementation of the NAR settlement. That's a really big thing too. So those, on any given day, I would say probably 40 to 50% are contract questions, and then maybe another 10 to 20% are landlord tenant, and then, various miscellaneous.
How do you train your staff attorneys to be able to answer those questions? Because if they aren't given areas of specialty, then they have to be cross-trained. So how does Florida Realtors do that? Because I'm sure you do a bang-up job.
I am continually impressed by how quickly our attorneys pick up on this stuff. Generally, we kind of allow them to enter the pool on the shallow end. We allow them to sit in and monitor calls. And then what we usually do is we'll train them using the emails first, because there they have the fact pattern right in front of them, and then that way if there's a question they don't understand, they can look it up and try to get to the answer before they call the member back. And then after that, again, we just allow them. We have a chat. Actually, most of the attorneys work out of a cubicle farm, but COVID made that, we couldn't sit that close to each other all the time. But we do have a chat, and we also make notes of all of our calls. So if somebody calls back about a question, they can go back and look at the original notes. They can go into the chat and ask the other attorney who answered the question, and then they can kind of go back and forth until they get the issues to where they want them to be. But usually, there's a lot of repetition. Like I say, counting time, you may hear that 5, 6, 7 times a day. And so after they've been at it for a few weeks, they kind of get into the swing of it. But again, like I say, our questions cover the waterfront, and, probate, trusts, land trusts, things along those lines. Ladybird deeds. We learn how to do all of that kind of stuff. And then, then we just handle it.
Let's go into an example.
Okay.
Just this morning, there was a fact pattern that was set forth on one of our real estate council email forums that came through. And with permission, I asked the person who submitted the question, I would like to pose that question to you and see how you would answer that, and maybe how that fits into what you normally would have to answer in your own real estate hotline. And just to be clear, this is a member of the fund asking other members of the fund what they would do in this circumstance. So this is a fund member who says, a realtor I work with who sends me business had a listing agreement with a seller that I just found out expired last summer, 2024. The realtor was involved with procuring a buyer who was first rejected by the association. That contract fell through. The seller and the realtor who manages the association had a falling out. Not sure if that was a factor. Sounds like it might be. The buyer is now approved by the association, and the seller wants me to write a new contract, leaving out the realtor. He is now not going to pay the realtor his commission because there is no seller-broker agreement. And there's a question here that talks about, I know that they should have a listing agreement in place. This agreement should be in writing. But in the case where an agreement has expired and the agent performs in terms of procuring a buyer, basically with the consent of the seller, does the agreement resurrect because of partial performance? Is there justifiable reliance? And then he goes on to say, I'm going to tell the seller I can't represent him or act as his title agent because of the conflict. What's your opinion?
The conflict is an interesting question, but I'm going to set that one aside for now. Okay, so you guys probably know, obviously you do know that we, Florida Realtors, produces dozens and dozens of forms for the use of our members, okay? Purchase and sale agreements, all that kind of stuff, and listing agreements. So some of the questions we get a lot on the hotline are asking to interpret contracts that we didn't draft or contracts where somebody made their own additions. We give guidance and education. We do not interpret somebody else's language. Okay, so the first question I would have to ask is this a Florida Realtors listing agreement? All right. If it's not, then there's not much I can do about it. But if it is, then I can go through the language of the listing agreement to find out if there is anything that might, like you say, resurrect their right to a commission. For
like
example,
a protection period.
Protection period, okay. Exactly. And once the protection period has expired, there may not be any real, basis for the compensation. Now, then you might veer into what I would call garden variety procuring cause law, but when there's a written agreement, usually the written agreement's going to control, and there's not going to be a basis if that agreement has expired. Now, I told you earlier that a lot of the members don't know issue spotting or know what's always important or whatever. There's an assumption made in that fact pattern that the agreement has expired. And I would add that there's not another agreement. Sometimes sellers will sign another agreement and they won't tell you that. All right.
No.
Right. And then the Florida Realtors listing agreement cuts off if another agreement is signed. Okay. So there's more facts that would probably have to be teased out here for me to get anywhere close. But the general answer is going to be if it has truly expired and the protection period has expired, there's probably not a basis for compensation. They could go after on a procuring cause, but another thing that some people miss is the fact that the broker must be the one that brings the lawsuit, right? And sometimes it's the aggrieved agent that wants to bring the suit, but they can't, not under Florida law. So then you would have to go to the broker and say, okay, we have a potential procuring cause situation. Because there's no written agreement, there's probably not going to be any attorney's fees. So do you want to go after this and then it's going to depend on how much the commission is, et cetera, et cetera, et cetera. So you can see how it kind of mushrooms out of what seems to be pretty simple and straightforward.
That's a good point. Well, let's talk a little bit about the conflict issue that this attorney is faced with, because I don't know about you, Melissa, but in private practice, it seems like it would happen all the time. You have an agent who is your referral source for a lot of your business, and you want to make them happy, but you also have clients to represent and you have ethical obligations. Should you close this transaction? Should you represent any of these parties? Is this a situation where the agent may need advice outside of their referral source and phone a friend?
Yeah, absolutely. And there can come a time during a call, and it happens pretty frequently, all right, where we get to a situation where now it's no longer discussion about the way the form is normally going to be, going to be interpreted or whatever, what have you. There may be additional facts. There may be additional stuff that was added to additional terms. in the contract or whatever. And then at that point, sometimes we have to say, okay, we can't give you legal advice about this. Okay. One of the conflicts that's interesting is that we may take a call from the other side of the transaction, and we can't be giving advice to one over the other or whatever. All we can do is kind of guide towards where they should go. And at that point, we will say, okay, you need to talk to your own attorney or, whatever. We also do not give advice that applies to their customer, client, whatever. All right. So we don't tell their seller or their buyer how to proceed. Okay. If it gets to that sort of situation, then again, we'll say they need to talk to their own lawyer.
What if their own lawyer wants to also talk to you? What if they want to call the hotline?
Okay. So again, it's a member service. So if it's a buyer or a seller, there's nothing we can do about that. However, and a lot of members don't know this, if they have an attorney that they are working with, okay, for whatever reason, brokers are working with having to, let's say it's the broker wants to bring this lawsuit or whatever, and they don't know whether they have a case or not. As you guys know, real estate law can be very tricky and complicated and stuff like that. So we do get calls from lawyers from time to time. Could you kind of point me in the right direction? Tell me where to go with something like that. And if the member calls and lets us know that the attorney is on the line, we have no problem talking to both of them. That is perfectly fine.
Okay. That would be a great service.
Absolutely.
For fund members to take advantage of.
Absolutely. I think it would get members out of a precarious situation where they know some of the answers, maybe not all, and maybe help some of their referral sources with some of the procedural questions they would have, because I would imagine you would get some of those. How do I set up my brokerage? Am I using the right forms to add agents?
Exactly.
How do I set up a satellite office?
Yeah, and we can comment on that and pretty much all licensing law, Chapter 475. We take a lot of calls about that. Yes.
You mentioned that you all are getting questions about condominiums.
Mm-hmm.
And so in today's environment, what are the types of questions that you are getting from the realtors? Because attorneys have lots of questions, and they may be very similar to what the realtors are. But what are the realtors calling the hotline and asking? Okay,
so it depends on the level of assistance that the member wants to give to it's usually the seller. Sometimes it's the buyer asking what documents am I entitled to or whatever. A lot of times it's the seller saying, okay, I can't get the documents that I need to provide to the buyer as part of the disclosure process. And so those are a lot of the types of questions that we get. And of course, now that's been vastly complicated by the turnover inspection report, the structural integrity reserve study, and the what's the last one?
You got the CERS,
the milestone inspection
report,
and then
the
CERS.
I always have to count it back from the SIRS to the whatever. But yeah, basically having to go through all of that and figure out ways. We also get a lot of questions. And I think this is, of course, because of the nature of the law, only going to increase special assessments, because sometimes sellers won't know that there's a special assessment. And this was even before the milestone inspection started, where the condominium would decide to do a major project and they wouldn't disclose it, and then the association wants the entire assessment paid off when the condo changes hands, and you can get stuck. So we get a lot of questions of that nature.
Especially with new condo riders coming out,
Mm-hmm.
New forms mean new questions,
Yeah.
I would guess. And with new legislation, possibly most undoubtedly coming through and coming down the pike, I would expect the forms to change yet again. Keeping your hotline
we
busy.
we always, like you guys, we always monitor all of the legislative changes and things along those lines. We're up to Condo 4.0, I think we call it, and so we're keeping an eye as to how that's going to change, and then the forms will change, and we'll be right back and answering questions about it again.
Well, here are my takeaways. The hotline is a great resource for your members, because what I'm hearing is that your staff attorneys have a great deal of knowledge and expertise about the day-to-day lives of their members and the challenges that they have. But that it is also a resource for fund members, because if you are representing a broker or even a licensee, you can reach out with your Florida Realtor member on the line with you and get information from Florida Realtors. But I can also envision where having this information about the existence of the hotline is a great thing for fund members to make sure this realtor that they're working with that has a question knows to call the hotline as an option, because you may not know the answer. I certainly wasn't familiar with all the ins and outs of Chapter 475. It's a tough law. It's a tough law.
Yeah.
And so just knowing that I could have referred some of the realtors that I work with to call the hotline would be a great resource.
So I guess that brings me to another question. What's a good example of when we should phone a friend? When should one of our attorney members say, I've carried this as far as I can go. Let's check out what the hotline has to say before we make a mistake?
Anything having to do with licensing law, anything having to do with brokerage questions, it would be a really good one. You think Chapter 475 is bad? Chapter 718 is really bad. So we have, pretty good grasp on that Chapter 720 HOA stuff and things along those lines. So anytime that you kind of get to I know I have to do additional research, but I don't know where to go next, that would be a really good time to call, because that we can at least point you in the right direction to, look at the statutes, look at the case law with respect to whatever your particular question is. And that, I think, is probably the most valuable thing for your members.
What about the calls you don't want to take?
I was just thinking about asking him, what's the call that you hate to get?
Okay, so it's interesting. You talked about our general education, but each one of our attorneys come from different areas. Like, we have attorneys that have worked in the mortgage department of a bank. I used to do a lot of probate litigation. We have a couple of attorneys that did a lot of landlord-tenant law, back in the time. And sometimes if you get one of those, you get a little bit of a bonus. I am comfortable answering some questions having to do with probate because I did it for so long, but most of our attorneys are not. And that is one of the easiest areas to get in big, big trouble, because you always have beneficiaries that want to sell the property and either don't tell you that there are other beneficiaries or don't tell you that there's not a will or whatever. And obviously you have members that are eager to get these properties on listed and things along those lines. But it's like that is the thorny one. That's where I basically say, anytime we take a probate question, it's stop, talk to an experienced probate lawyer.
So it's questions like, who should sign the contract? Or, how do the probate questions come up in the context of a question to the hotline?
A lot of times it'll come up with authority, who has the authority to put the property on the market. And, you'll have a property there's no will. We have a lot of properties in the state of Florida that are vacation homes, but the person isn't domiciled here. So, they may live up north somewhere or lived up north somewhere. So there's actually a probate administration going on in a northern state, and they haven't opened an ancillary estate down here yet. But you've got you've got the beneficiaries just wanted to, I'm not moving to Florida. I want to put it on the market and stuff like that. Divorces too. I'll throw that one in too. Same exact thing where you have one of the spouses wants to sell the property and the other one doesn't. And, we really try to keep our members out of the middle of those, because that's just not a headache you need.
Well, it sounds like your staff attorneys have to be incredibly knowledgeable, but it also seems like there's never a boring day.
Oh, no.
If you're on the hotline.
Yeah.
Never a boring day, because you get all kinds of questions.
Oh, yeah.
So.
All kinds of weird stuff.
And the phone goes both ways. It sounds like sometimes we have to phone a friend in you, and sometimes you have to phone a friend
Oh, yeah.
for one of us.
Yeah.
Yeah. Well, Rich, thank you so much for being with us today and sharing what's going on at Florida Realtors. I hope you share my sentiment about the really good relationship that the fund has with Florida Realtors. Absolutely. And how we try to support each other when new laws come along and new regulations come along. More and more I'm coming them from I'm pointing up Washington. Because it really is important that attorneys understand the challenges that the real estate agent is dealing with out in the field, but also that realtors understand the challenges that attorneys have in closing a transaction properly.
Right.
I mean, that is our goal and that is our challenge. So I want to thank everybody for joining us today and listening in, reminding you that we will push this audio out on the podcast. So look for that in a couple of weeks. And as usual, thank you for your support of the fund.